Good evening, everyone. My name is Diane Charles Sandy. The topic I'm going to discuss this afternoon is alternative dispute resolution, which falls under the labor relation process in action. The overview. What is alternative dispute resolution? What are the advantages and disadvantages of alternative dispute resolution? What are the types of alternative dispute resolution? So here we have mediation and arbitration. Alternative dispute resolution is used as a method of resolving disputes between parties, both as an alternative to commencing litigation and even after litigation has commenced. The process is a voluntary one and, depending on the method adopted, can be without prejudice to the party's strict legal position. With the aid of an independent third party assisting parties in their deliberation, disputing parties are able to arrive at a mutually acceptable resolution which is cost effective. Here we have the advantages of alternative dispute resolution. It takes a shorter period of time to resolve the dispute, greater flexibility with regard to the selection of the person to deal with the dispute, thus allowing parties to select person with the appropriate experience. It is a more cost-effective option to litigation. The disadvantages of alternative dispute resolution. Unlike the certainty and the enforceability of a court judgment, some alternative dispute resolution cannot be forced upon the parties. There is also the possibility of a lack of full disclosure during the negotiation, which means a risk that decisions are made with less than all the facts. Types of alternative dispute resolution. Mediation. In mediation, an impartial person called a mediator helps the parties try to reach an acceptable resolution of the dispute. The mediator does not decide the dispute but helps the parties communicate so they can try to settle the dispute themselves. The key features of this process is that it focuses on the interests of the parties. For example, a dispute with a neighbor over the brightness of the outdoor or outdoor of their lights is hardly the type of claim that merits a lawsuit. In this type of situation, it may be wise to seek mediation to end the conflict. Arbitration. Arbitration is the process of bringing a business dispute before a disinterested party for resolution. The third party, the arbitrator, hears the evidence brought by both sides and makes a decision. Sometimes that decision is binding on the party. For example, in Trinidad and Tobago, arbitration allows a third party, in this case the industrial court, to impose a solution. So once a matter is determined by the industrial court, then it will decide the outcome of the dispute and both parties are bound by it, meaning subject to appeal on a point of law only. For example, the company that I'm employed with, the arbitration process in which they follow. For example, if there are employees that are aggrieved, they can voice their concerns through the union representative that can raise their issues. It is a joint consultative committee that with the executive management and the union officials meet in order to reach a resolution before it reaches the Ministry of Labor or the Industrial Court. It should also be noted that only Industrial Court or the Ministry of Labor can arbitrate because they alone hold the power under the law to arbitrate under the Industrial Relations Act. Arbitration can be binding and non-binding. Binding arbitration means that the parties wave their hands to a trial and agree to accept the arbitrator's decision as final. The non-binding arbitration means that the parties are free to request a trial if they do not accept the arbitration decision. These are the references that I got to follow. I hope you understand, and I thank you for listening.